Welcome to celebrating 20 years of medical cannabis advocacy. I'm going to be going over the history of Americans for Safe Access with you. So of course, before we can start diving into the work that we did at Americans for Safe Access, it's important to look back at the work that had been done before we started Americans for Safe Access that brought us to the political landscape we were in today. And if you want to learn more about that history, you can go to our website and search for a patient's history of medical cannabis. So we started Americans for Safe Access. I just want to bring you back to 2002. There were 11 dispensaries in the country, and they were all operating illegally at the local, state, and federal level. There was 80% support nationwide. So I was like, this is only going to take 2 years. We have so much support. There were 8 states with medical cannabis laws, but those laws were just criminal exemptions. So that meant if you got arrested, you could take a letter from your doctor to show the judge. But there really wasn't much implementation oversight of these laws, and there were no legal access programs. There were 2 countries that had medical cannabis laws, Canada and Netherlands. There were about 30,000 legal medical cannabis patients in the country, and the Department of Justice had been using civil and criminal actions to go after access models and to go after doctors. There was no defense in federal courts for medical cannabis. So if somebody got arrested, the jury would just basically hear that they were a drug dealer. Cannabis was Schedule I in the US and at the UN. And we were having a hard time getting doctors to participate in the program because of the threat from the Department of Justice. And that was the Clinton administration. So fast forward to today, and today there's over 9,000 dispensaries, and these are all operating with state licenses, and they're protected by the CJS amendment. There's 93% support nationwide, 38 states with medical cannabis access programs. There are 65 countries with medical cannabis programs. There's over 5 million legal medical cannabis patients in the US. Feds have been forced to stop rating patients and their providers. The feds are now saying that marijuana is not an FDA-approved medication, which I think we agree with, much better than marijuana has no medicinal value. Cannabis has been rescheduled at the UN level, and cannabis in the US with a percentage of less than 3% THC has been removed from the Controlled Substance Act altogether. The DEA has been forced to stop pushing the gateway theory. That was that if you used cannabis, you were going to become a heroin addict. There are over 500,000 people that are working in the medical cannabis market. And our current president says that no one should go to jail for cannabis. So how do we get here? Well, it wasn't by accident. And during this presentation, I'm going to take you through the work that patient advocates did to help shape the medical cannabis arena that we see today. So let's go back to ACE's mission. Our mission is to ensure safe and legal access to cannabis for therapeutic use and research. And to us, this means that there's international, federal, and state recognition of medical cannabis, that medical professionals can prescribe medical cannabis as frontline treatment options or as an adjunct therapy. This would mean that we have an end to stigma and discrimination for patients and their medical professionals and providers. Means that patients and caregivers have the information they need to make educated choices about medical cannabis therapies, that patients and medical professionals can incorporate a variety of products and delivery methods to create a program that works for patients, that patients can trust the labels on products and that these medicines are free of contaminants and pesticides, and ultimately that medical cannabis is covered by insurance. So starting from the beginning, we sat down and developed a strategic plan of how we are going to accomplish these goals. And if you have been working with me for very long or and been in a coalition or group with me, you've probably seen me pull out butcher paper or Post-it notes and really just dive down into how to accomplish our goals. And the power of strategic planning, it's, you have to define your values and goals. You have to break down power to really understand who can make the decisions to meet your goals. You can really take advantage of news stories and topical matters and point out how your issue is like something that's happening today. You can really look at how to plan ahead, but also, knowing how to use different tactics in your toolbox and knowing when to use those. And so everything we've been doing along our pathway to get to safe access always comes back to a strategic plan, which we actually revisit several times a year. So anytime something changes, you can go back to your strategic plan and make sure that you're on track and that you're utilizing the best tactics. So going back to 2002, so when we looked at our political landscape, we noticed that some of the conditions were that there were individuals that were willing to commit public federal civil disobediences to provide medical cannabis patients, and that they were willing to say not guilty in front of the courts. And this was important because in the war on drugs, because of the harsh penalties, between 97 and 98% of those drug charges end in pleas, where people just plead guilty to get a lower charge. And so the public doesn't really get to see what the drug war is doing. And so the fact that people were openly breaking these laws, openly getting arrested, and then going to court, this is what, in California, before they passed the state law, it was individuals that had been arrested like Dennis Perone and the Corrals. By saying not guilty, the state was able to say, this isn't what we want our marijuana laws to do. And so at the federal level, this was a huge opportunity for us to show what the war on drugs was doing to patients. But we also had some major issues, which was that the public discourse about the federal raids was really from a legal perspective, that federal law trumps state law, versus really looking at the patients that were being impacted by the actions of the Bush administration. And a lot of Californians actually thought that the whole medical cannabis experiment was over, because they kept hearing headlines about the feds going after doctors or federal government, going after and prosecuting patients. And so we also had to educate people to let them know that this was still happening, and that actually these raids were a violation of patients' rights. And there was also this issue that, patients were suffering not just from federal enforcement, but also from the lack of implementation. So we had to, part of ending these raids and the prosecutions was a big public awareness campaigns. And so one of the first things we did was we actually put a call out to activists across the country, and actually identified people in over 55 cities and that joined us in an action on June 6th, where we actually served the DEA with cease and desist orders. I said in over 55 cities. And in some of these actions, we actually, there were civil disobediences. People closed down the Department of Justice in DC. We closed down the courthouse, federal courthouse in San Francisco. And this was a way to take the headlines about the federal raids and connect them to patients, and keep this on the mind of people, but also to put the Bush administration on notice that that we were watching, and that they wouldn't be able to carry out these campaigns without a public reaction. So we also started doing ads. There were people going to trial, and when people were being prosecuted at the federal level for medical cannabis charges, they weren't allowed to talk about the state law. They weren't able to talk about their health condition. And so all jurors were hearing was, the fact that they were in possession of or selling cannabis or distributing cannabis. And so we created ads that ran in papers across California. It's actually a picture of my good friend Mike Gray, who's unfortunately not with us anymore, but he helped me put together these ads. We also, a part of building a movement to bring awareness. We had to bridge the issue of medical cannabis to other issues, to human rights issues, to drug war issues, to racial justice, to states' rights, safe communities. And so we were able to really build a strong coalition. And over the years, that coalition has grown. We also created chapters and started working with affiliates across the country. Many of these chapters are still with us, and they every day are helping carry out the mission of Americans for Safe Access. We also had to provide resources to train those advocates. So a lot of the beginning days of building the movement included me driving around the country doing 23 city tours of California, 8 city tours of Montana, finding like-minded people and giving them the tools to work on this issue, both locally and at the federal level. A big part of building a movement is making sure that you're providing resources for the stakeholders. So that meant in the early days for patients and medical professionals, providing legal manuals so they understood what the laws were. Meant creating booklets about medical conditions. And in fact, when we first started creating these booklets, we couldn't get doctors or researchers to put their names on it because they were so afraid of federal prosecutions. We also had to train public defenders to make sure that they were helping patients, stand up for their rights. We also trained people working in dispensaries on how to work with medical cannabis patients. And we also trained patients to know and exercise their rights so that they could have successful law enforcement encounters. And we also tracked state and federal interference for years. So we encouraged patients to let us know when and if they were being persecuted. We also had to provide resources for cannabis providers. And in the early days, this included raid preparedness trainings, robbery trainings. It meant, making sure that they were at the table to create product safety protocols, but also, helping them advocate in their communities to explain what medical cannabis dispensaries were and why they were needed. And of course, we have ongoing support of cannabis providers. So our raid preparedness trainings in the early days included role plays of how, what people could expect from the DEA when they came to their door and how to successfully go through a raid. And that also meant by, going through lots of scenarios where all they said was, I choose to remain silent and I want to speak to an attorney. And this tactic, not only did it help people successfully go through the raid itself, which were scary, but they felt prepared, but it also meant that prosecutors weren't getting more information from the raids because everyone was choosing to remain silent. Then we also created a raid response, which this campaign included have media lists, making sure that we had media that wanted to know when and if a raid was happening. We had public officials that were ready to jump on a teleconference. We had patients with signs in their cars. In the early days, we had phone trees that actually evolved into text messaging systems. And between 2002 and 2014, the DEA carried out over 500 raids, and we responded to all of those. So ending the raid also meant that we had to let people know that they were happening and know that California still had medical cannabis laws. And so over the years, we had lots of actions, lots of opportunities to protest Asa Hutchinson when he came to downtown. We did the raid responses after raids. Because the raids kept happening after we served the cease and desist order, we had an action where we actually evicted the DEA. And again, we just kept seeing protests after protests following every raid. And then, of course, we had to support those people who were going to jail and who were saying not guilty. And this meant educating jurors about their rights, and knowing that if they didn't like the law, they actually had the right to not find someone guilty. I think one of the most successful stories of court support was in the case of Ed Rosenthal, where after he was convicted, actually Hillary McQuay, who was a staff member at ASA, went to the jury afterwards and asked them, how could you convict him? Didn't you know this was medical? And a few hours after that conviction, they called us and they said that they felt duped. And we actually held a press conference a few days later with a majority of the jurors who called on the federal government for a new trial. And this actually really slowed down and actually brought most of the prosecutions to a halt for years. So, we brought this fight to DC, where in 2003, Congress introduced the CJS amendment for the first time. Sam Farr, Rohrabacher, started us off in way back in 2003. The first vote, we got a little more than a third of the House to vote for it. And then we began actually targeting congressmen who voted against us. But as we were getting all this national attention about the federal interference, we started hearing from people in California that told us actually it wasn't just the federal government that they were worried about. They were actually concerned from local police and the fact that they had issues, in access in their home state of California. So we held what would be the first of many stakeholder meetings. We held these in many of the states. And from this, we learned that there was constant attacks from law enforcement, that law enforcement was taking their property and not returning it, that there were no protections for patient collectives, which is what we called dispensaries in the early days. There wasn't much guidance for patients and caregivers. They weren't sure when they were following the law and when they were not. And they really wanted to see clarifying language from the legislature to move to transition from criminal exemptions to legal protections. And so out of that meeting, we actually passed a piece of legislation that clarified the rights that was signed the next year into law. But it also made us realize that if we were going to really transition the state law, that we needed to provide resources for advocates to understand how to participate in implementation, how to do citizen lobbying, and how to articulate what it was they wanted from legislation. And so one of my favorite cases in California was that I'd mentioned we kept hearing about cases where law enforcement was taking patients' property and not returning it. And so we actually created a report where we put out, to patient community for people to call us with any state arrests that they'd had over the last 3 months. And we actually documented over 250 incidences and compiled this report out of compliance, which we took to the governor and to the attorney general, Bill Lockyer at the time, and asked them to change the policies of law enforcement. And they refused to do so. And so we actually filed an injunction against the California Highway Patrol to stop seizing medical cannabis patients, and filed a lawsuit against the CHP for violating patients' rights. And we won that lawsuit. In winning that lawsuit, we compelled the CHP to revise their policy, which included, very specific instructions on what to do if they encountered medical cannabis patients. We actually received $75,000 from that lawsuit, which helped us create our legal department. But the ripple effect from this was not only that we started seeing law enforcement respect patients' rights, but every state law that was passed after this lawsuit included guidance for law enforcement to protect patients' rights. In 2005, the Supreme Court basically overturned a Ninth Circuit hearing saying that federal law could continue, and that feds could continue their attacks on medical cannabis patients. And so this led to a whole new series of raids and activities. In California, we upon our CHP victory, we started looking at the courts to help us with a lot of other issues that we couldn't get the state legislature to do. And so we had to sue the Department of Motor Vehicle because they were taking away people's license simply for being medical cannabis patients. We had to sue a company for firing someone simply because they were a medical cannabis patient. Unfortunately, we lost that lawsuit, and we were able to introduce legislation that year, which passed but was not signed by Governor Schwarzenegger. But this year, we actually finally did pass those protections in California. But even though this case didn't win, we still had the ripple effect of legislatures across the country, including employment protections in their legislation to avoid these types of lawsuits. And then the next case, which was super exciting, was that in the city of Garden Grove actually refused to return a patient, Felix Kaw's property after his charges had been dropped for possession. And so we helped him write a letter to get that back. And after refusing, we actually filed a lawsuit. And to our surprise, the city of Garden Grove said what we'd been hearing a lot of other law enforcement say, which is that they couldn't return the property because that would be violating federal law. And so they actually appealed our case to the 4th District Appellate Court, federal court, basically, trying to get the courts to say that they didn't have to follow the state law because of preemption. And this actually came to our delight because we really wanted to get preemption in front of the courts. And the 4th District actually agreed with us that the federal law does not preempt state law, so that it can exist in conflict, and the federal government, they can carry out enforcing their laws, but state officials had to follow state law. And they appealed this to the U.S. Supreme Court, and the Supreme Court denied review of it. And so what this meant, for law enforcement and for patients in California, is it meant that we started seeing less incidences of cannabis being seized by law enforcement, and that we also saw patients getting their medicine back. But what we also found is that in California and many of the other states, after we passed state laws, state officials were refusing to implement the laws because they were saying it was preempted by federal law. And so the impact of this one case by this one patient, Felix Kaw, had ripple effects across the country. And so this meant we were able to start implementing medical cannabis laws in several states that had been holding it up. We also received a huge sum of funds from legal fees from the city of Garden Grove. And what this also meant is that in the future, when we threatened to sue, people paid attention. And so creating safe access, we also, dispensaries were not welcomed with open arms. I know people are still struggling with this in their states, but we had cities that were banning medical cannabis dispensaries. We had to issue reports looking at impacts of dispensaries in cities, and we had to hold campaigns city by city, county by county in California. We put out guides for cities and for advocates to work with their cities. And through a lawsuit, we ultimately got the California Supreme Court to agree that medical cannabis dispensaries could exist. And ultimately, we passed legislation creating a licensing program in California. A big part of also sort of stopping the raids at the federal level was and making sure we could implement the laws at the state level was holding politicians accountable. And one of the most egregious anti-medical cannabis people in California was the DA from Los Angeles, Steve Cooley, who would hold luncheons with the California Narcotics Officers Associations with topics like the eradication of medical marijuana dispensaries. He would always talk horrible things about medical cannabis in the press. And so we got our revenge when he ran for attorney general in California. We brought together a coalition of not just medical cannabis, but marriage equity folks, environmentalists, and labor, who had all also hated Steve Cooley. And we were able to defeat him, getting Kamala elected into her first office as Attorney General. But over this time, the raids were still continuing. We are still seeing aggressive campaigns against medical cannabis. And so in 2006, Americans for Safe Access, we opened our office in DC, allowing patients to have daily representation on Capitol Hill. And we met with all senators, all members of Congress. But someone who really helped us with our strategy was Senator Barbara Mikulski, who was a Democrat who we thought would be supportive. And when our first meeting, she told us that there were 3 things that we needed to do before she could advocate for us on Capitol Hill. And those 3 things were that she wanted us to see labor involved, she wanted to see the herbal medicine industry involved, and she needed us to pass a medical cannabis program in Maryland. But through this office, we began working with senators to create requests for GAO reports, and we just started seeing a lot more activity on Capitol Hill, really looking at patients' rights and medical cannabis. But the raids still continued and continued and continued all across the country, not just California. These were in Colorado, New Mexico, Michigan. And then Obama was elected, and he had said on the campaign trail that he would stop the raids. When he came after his election, we were continuing to advocate to make sure that we saw a change in policy. And finally, in October of 2009, we got what was known as the Ogden memo, which was basically guidance policy for U.S. attorneys and Department of Justice around medical cannabis laws. But the raids still continued, and they actually got worse. And we started seeing, instead of just one raid at a time, we would see them attack 25 people. And we started seeing this in states where we had never seen federal interference before. And then we started seeing letters from U.S. attorneys' offices to states threatening them, telling them that their state laws were in conflict with federal law. We even started seeing them attack landlords again, threatening to take their property and put them in prison if they didn't evict medical cannabis dispensaries. Americans for Safe Access filed a couple lawsuits against the Attorney General, against the DEA, to try to stop the progress of these attacks. And through this, we got another memo. And this memo actually was from James Cole, who said, this is very much out of 1984, that actually we all misunderstood the Ogden memo, and that he didn't mean, the Department of Justice didn't mean to protect state laws, and so U.S. attorneys could do whatever they wanted. And so this meant many more raids, but it also meant that we were getting more state officials coming out. But this also meant a return to federal prosecutions, which, even though we had seen all of those raids over that 12-year period, most of them were what we called cash and grabs, where they would just go in and raid and take all of the product in cash and then leave. But now we started seeing the prosecutions happening again. And so we had to go back to public awareness, letting people know what was happening, letting people know that they had to use their voice and demand that Congress change these laws. We had to remind people that were voting for Obama that actually he didn't keep his promise. And so we started bringing medical cannabis patients to DC to lobby. And this meant that they were able to bring their concerns directly to their elected officials. In 2013, we issued a report called What is the Cost? What's the Cost? And we launched the Peace for Patients campaign. In the report, we highlighted, what was the cost to human lives. We kept hearing from members of Congress that they thought that the Obama administration had stopped the federal campaign against medical cannabis. So we had to put all of this information together. So these are all the people who had been arrested or spending time in prison. We estimated that the federal raids cost over $300 million and that there was over $1 million that had been spent on arrests alone. And that because of the medical cannabis laws, over 480 years had been handed out in prison time. We had to show them that even though these raids were happening, that actually more states were passing medical cannabis laws. By 2013, we were up to 20 states, but we had seen over 500 raids. And then we wanted to really break down what this interference was costing, that this wasn't just something that didn't have an impact. And all of this from the combination of our report and the visible raids, we got another Cole memo. And this memo actually created guidances for states to follow to keep the Department of Justice from attacking them. And so we thought, great, we finally have the protection we need from the Obama administration. But unfortunately, when this memo was issued, we started hearing from U.S. attorneys that this didn't really make an impact. So we issued a report, Third Time is a Charm, and we actually broke down how each one of the states was already following these guidances in hopes that we wouldn't see any more raids. And in 2013, we brought activists back to Washington to meet with their elected officials, to bring the report and remind them that this was still happening, that we still needed Congress to step up, and that the Department of Justice guidance memos were not enough. And then there was a federal raid on a family in Washington, and Larry Harvey was the target was one of what were called the Kettle Fall Five, and he actually came to Washington to lobby. So it was after our lobby day, but we took him from office to office to office, telling his story and letting people know that he was not protected by the Cole memo. And so this led to Congress finally introducing the CJS amendment again. Because of all of the memos from Obama's Department of Justice, Congress felt like this issue had been taken care of. So it was really through patient advocacy and us bringing Larry and bringing patient advocates to DC and the release of the What is the Cost report that we were able to get Congress to introduce this amendment and ultimately pass it through Congress. After this passed, we actually we had a campaign that we launched called Vote Medical Marijuana. And in 2014, we ran attack ads for Congress members who had voted against the CJS amendment. We ran ads in favor of people who had stood up for medical cannabis, and we created voter guides for all federal offices. And the impact of this paid off. But remember when I told you about Barbara Mikulski, who had given us sort of a task list of things to do if we wanted her support? Well, it turns out that by 2014, we had been able to work with labor in a major way. We had UFCW organizing cannabis workers in California and other states. And then we also began working with the American Herbal Products Association to create product safety standards. So we had 2 of the 3 off the list. And then finally, we passed HB 881 in Maryland, creating a medical cannabis program. And so actually the day after that program passed, Mikulski's office called us for a meeting, and she asked what we needed of her. And it just so turned out that at this time, Barbara Mikulski had a very important position. She was chair of the Appropriations Committee. And so she single-handedly brought medical cannabis through the committee, and ultimately creating the passage of the CJS amendment for the first time. And of course, finally, protecting medical cannabis programs, the providers and patients from federal interference. But after those passed, the Department of Justice said that they didn't think that this amendment was going to have that big of an impact. So we had to stay on that, of course, because it's a amendment to the appropriations bill. We had to pass that every year. And we had to, continue to put pressure on Obama to create a comprehensive program. But after this passed, this allowed us really to start creating more comprehensive programs in the states. We started creating the State of the States report and working with state legislatures and patient advocates to improve their laws or pass new laws. And of course, for every state law and for every improvement of a medical cannabis program, there are tireless advocates that do this work. And we're happy to call them friends and family. But again, anytime you see a headline that a medical cannabis bill has passed, just know that there's somebody who has, taken off time from work, taken time away from their friends and family to work tirelessly at the legislature, reviewing legislation, writing amendments. So we're so grateful to the patient advocates around the country that continue to do this work. And they've been pretty successful. We can see, over the years, we've really made a huge impact, and there's really only 2 states left that don't have some type of medical cannabis law. And we continue to fight in Washington for medical cannabis rights. In 2016, we had the CARES Act. Then we had Trump come into office, and we had, the Cole memo actually was pulled away. We haven't seen any federal activity. Luckily, Sessions was distracted by Putin and other issues in the Trump administration. But to today, there's still no guidance memo from the Department of Justice. But we continue to bring patients to DC to lobby. The last few years, we've had to move our conference online, but we still work with patients to make sure that they're talking to their elected officials. And this year, for the next session, we're going to be pushing for comprehensive legislation, which we'll hear about later in the conference. But part of our strategic plan has also meant that we've been able to respond to events and make sure that we can advance safe access. And a big example of that was the opioid epidemic. Right away, obviously we know that patients who use cannabis have are less likely to overdose on opioids, but there were a lot of other impacts as well. And so we really utilized this topical event to let people know about medical cannabis and its role in pain, but also to know that the state legislature and state programs, many of them didn't include pain. And so this gave us an ability to really explain to people how many steps it really takes for a patient, that has an illness or a new injury to actually get access to medical cannabis, because most of the medical cannabis state laws were created to ensure as few people as possible got into them. And so we really utilized this opportunity to explain to people, how many steps were in the way of patients being able to get access. And we actually were able to generate quite a bit of media coverage about this. And what we found in our 2019 State of the States report was that we were actually able to have some pretty intense impact. I think that one of the biggest was that for years, states did not want to allow pain as one of their qualifying conditions. In fact, in 2016, when we first issued our report, Connecticut, DC, Florida, Illinois, New Jersey, and New York, which are all very big markets, did not include pain. And today, all medical cannabis programs include pain as a qualifying condition. And then, of course, we had the COVID pandemic. And when we started hearing about lockdowns, we jumped into action and created an emergency action calling on governors to include medical cannabis as an essential business, but also there were a lot of issues that patients were facing that we knew would be exacerbated during the pandemic. We were able to, successfully get medical cannabis businesses included as essential businesses. But we also continued to provide resources for patients and workers who were deemed essential to make sure that they stayed safe. But through our call to action, it was pretty exciting to see that every medical cannabis state responded to patient demands, that every state, except for a few, actually allowed delivery. This was something we've been fighting at the state legislature for years. Almost every state but a few allowed for curbside pickup. Every state but Missouri allowed, actually granted the medical cannabis businesses essential status. And every state but Arizona actually allowed telehealth doctor visits, which is something we've been fighting for years as well. But what's also exciting is that once we were able to gain these rights in the sort of emergency protocols to deal with the epidemic, we were actually able to get states to retain those, which was a huge boost for safe access at the state level. We also, utilized the current events around national sports stars getting, suspended for medical cannabis use, and through advocacy and support of these issues, most national sports in the U.S. Have stopped their drug testing protocols with marijuana. Another aspect of patient advocacy is, making sure that these stories that often happen, outside the headlines, that we make sure that the public know that these are happening. And one of those cases was actually Norman Smith. He was actually denied a liver transplant from Cedars-Sinai. And because transplants are done through private companies, we couldn't sue them, but we advocated for him and we helped him get his story out there. And unfortunately, Norman passed without getting a transplant. And we were so grateful to him for his bravery in his last days. But his fight didn't go unnoticed. We were actually able to pass a bill in California to stop discrimination against medical cannabis patients. And this was effective actually just right after this passed. Patients in California, Tamara was actually able to get reinstated on the transplant list and was able to get her transplant, and she's doing well. So if you want to get more inspired by stories of patient advocates, I encourage you to go to the section of our website. Every month in our newsletter, we highlight patient stories. I also want to talk a little bit about passing a law is just the beginning. So a lot of work we do is working with the various stakeholders to implement those laws. A perfect example is Ryan's Law that passed in California in 2020. We created guides for physicians and patients and healthcare facilities. And then we actively keep an eye on it, allowing patients to report incidents of discrimination. And rescheduling is an issue that often comes up. We were actually part of a rescheduling petition in 2002, the first year that we'd started, but that rescheduling bill sat there for 9 years. And ultimately, through suing HHS to move this forward, we were able to get our day in court. And we were still denied rescheduling, which I encourage you to read all of those filings. We also utilized something called the Data Quality Act to challenge misinformation at HHS. And this process actually took us into a federal court where we were able to create a position for medical cannabis, but the case was ultimately denied because they said we had to wait for the rescheduling petition, which you guys know how that went. So after our rescheduling petition made it through the process, governors in Washington and Rhode Island, they filed a rescheduling petition that was denied also. Our response to that denial was actually creating our own version of the 8-factor analysis, which you can find on our website. When we started working in DC, we got this sort of laundry list of issues that the policymakers told us that there was no way we could change federal law. And one of those issues was this gateway theory, and that cannabis caused psychosis. The gateway theory was that if you use cannabis, you would be a heroin addict a few days later. And so we started a campaign advocating that DEA change misinformation. We filed petitions. We lobbied Obama to try to do this before he left office. That didn't work. And so we used the Data Quality Act, now called the Information Quality Act, to challenge the information that the DEA was putting out about cannabis. And the best part about this Data Quality Act challenge was that we actually just used the DEA's own words and information that they had provided in their denial of the rescheduling petition. And the DEA ultimately removed this information from their website and publications. One of the other issues we kept hearing on Capitol Hill was that they couldn't change federal law because that would put the US in violation with our UN single treaties. And after over decade-long campaign that include getting the World Health Organization to re-examine their position on medical cannabis, in 2020, we were successful in getting the UN to change the scheduling of cannabis to include acceptance of the medical use, which means that actually the US is in violation of the UN single treaties with their scheduling of cannabis at a Schedule I. One of the other barriers we kept hearing was that there was no way to safely produce cannabis. There were no guidelines. And so Americans for Safe Access, we partnered with the American Herbal Products Association and the American Herbal Pharmacopoeia to create those product safety guidelines. Those are now adopted in most states. And through the patient-focused certification program, we work with regulators and with cultivators and manufacturers and dispensaries to implement those product safety protocols. We also heard that medical cannabis was just an experiment in a couple liberal states. And of course, you can't really say that today. In fact, you may not know this, but our name, Americans for Safe Access, came from Asa Hutchinson, who was head of the DEA when we started our campaign, which we thought was going to be a campaign, not an institution, so that we could be Asa versus Asa. But Asa Hutchinson now oversees a medical cannabis program as governor in Arkansas. So definitely not just a handful of liberal states. Over the years, we've had some unexpected challenges that we're still working to overcome today. I think one of the biggest ones is that after 25 years of working at the state level, we still haven't passed a federal law. And so, these access programs that were supposed to be a triage for patients, are now starting to get infected because they've been in triage for so long. The same is true of, when we passed the CJS amendment, we thought that was just going to be triage and that would shortly be followed by comprehensive federal legislation for medical cannabis. We definitely didn't expect the CBD market to villainize THC and keep states from passing comprehensive medical cannabis laws. A lot of our original donors over the years, they were not from cannabis businesses. Once they started seeing the success of the cannabis marketplace, they felt like we should be getting our funding from those people. The cannabis market, many of the donors we had from the beginning are no longer in the market, and we get very little support from the current cannabis market. The unregulated cannabinoid market, that's a result of the Farm Bill, I think is leading to a potentially scary blowback. And I think one of the biggest things was that, we didn't expect for medical cannabis to become sort of an afterthought on Capitol Hill. The 117th session congressional session has been dominated by adult use proposals. And we're having a hard time finding bandwidth of politicians to carry back the banner of medical cannabis. I still know that medical cannabis policies have a chance to move forward if they're given their day. And so we're hoping that in the 118th, we can return to looking at medical cannabis programs. And summing up the 117th session, we did hear Biden, who still uses the word marijuana, tell the Secretary of Health and Human Services to look into scheduling. I think we know where that will go. And we did see some of our biggest opponents in the past, Feinstein and Grassley, actually pass a research bill that was signed by Biden. And so we've come a long way in many ways, but there's obviously still work to do. And of course, we couldn't have done any of this work without the ASA volunteers and staff. This picture makes me want to cry. I miss a lot of these people. People like Joe Elford, who was our staff attorney until he was so successful that we didn't have anyone else to sue. Chris Hermes, Rebecca Saltzman, our current staff, Jeffrey Marshall, who is putting together this conference. The list goes on and on. Of course, over the years, being a patient advocacy organization, we've lost many of our friends that have helped us move cannabis policy forward. And if you want to learn more, everything that was in this presentation can be found on our website. And if you want to join us, you can become a member today. And I also want to tell you about a program. We're actually trying to document this 20 years of advocacy. So if there's a story that you didn't see in here or something you want to say about Americans for Safe Access, please go to safeaccessnow.org /tribute to submit a video story so that we can collect all of this amazing history. Because one thing I learned putting together this presentation is that if we don't document our own history, no one else is going to tell it. So thank you so much for this journey with me, celebrating 20 years of medical cannabis advocacy. And I just want to say thank you so much. It's been my honor and privilege to be a part of this last 20 years with so many amazing, brave, and courageous people. On behalf of Americans for Safe Act staff, the board, and all of our members, we want to say a very special thank you to our Unity sponsors for the 2022 Unity Conference. This is our 10th annual conference, and I know many of these sponsors have been with us for the last 10 years. So I want to say a very special thank you to Dr. Bonners, to Metric, to 3C Cannabis Consulting, to Canopy Growth, Tacoma Wellness, the American Herbal Products Association, Cannabis for Cancer Declaration, Cannabis MD, Columbia Care, Council for Federal Cannabis Regulations, Healer, the National Pain Relief, Supply Chain OpEx Consulting, the University of Maryland School of Pharmacy, UKTI Collective, and Evoke. Again, thank you so much. This has been a great conference, and we couldn't have done it without you all.